Hey, good afternoon. Carl Rominger here, answering your legal questions. That's right, 540-0580, 540-0580. If you have a legal question, a legal concern, got in trouble, anybody got a DUI, maybe you got arrested this past weekend for driving down the road, don't think you did anything wrong, not sure whether you should have to go to jail or not, call us, 540-0580, Family Law Matter. And, of course, as always, you can go to weekendappointment.com, where you can post your questions throughout the week. And, of course, we'll take a few of those on the show today as well. And we also have pictures of a deer up there. Last week we had to run a best of show because I was in New York, and I was thinking about doing it remotely, but I decided with the hunting schedule being what it was that we would go ahead and run a best of show. But if you want to see a picture of a very large deer that my friend Brent Schickley shot, and which I had to help drag out of the woods because he's in pathetic shape and needed me to basically throw this big deer on my back and climb a mountain with it. You can go to weekendappointment.com and you'll see it under the announcements section. You just have to be a registered user to see those pictures as well as some others. 540-0580. Donna, you're on WHP 580 with Carl Rominger.
Hello.
Hi, Donna.
Oh, okay. I would like to know, by law, must a father pay child support when the child is going through college?
The answer is, in Pennsylvania, no. Once a child is over 18 years of age and emancipated from high school, there's no duty to pay any longer in Pennsylvania. Our Supreme Court said that parents in intact marriages have no duty to pay for college. Therefore, parents not in intact relationships have no duty.
Oh, okay. Well, thank you, because, it was a situation where it was said that he would have to pay all through college for the boy, but no. Okay, thank you very much for your information and your help.
Okay, thanks, Donna.
Okay.
And little side note there, Donna, and anybody else who's thinking about this, there is no duty to support a child through college in Pennsylvania. Other states have different laws, and some states do require it. So if you're paying into another state for child support, you've got to check that state's laws, number one. Number two, you can oblige yourself by agreement to do that. And we see that in a lot of divorce agreements where one or more of the parties agrees to pay for college education as part of a negotiated divorce settlement. And since a lot of people do these things on their own and then show up in our offices with some signed crazy document, or the other side has a lawyer and they were unrepresented, we do see a lot of people bargaining, saying, well, I thought I had to support him anyhow. So, you're not gaining anything by agreeing to that. There might be a moral obligation to support your child through college, but there might not be. That's an individual decision, best left to the individual. So don't just sign away on that. Don't force yourself into that kind of position. 540-0580. Corey, you're on WHP 580 with Carl Rominger.
Carl, how are you today?
Good, man. What's going on?
I had a little bit of a real estate question, kind of more like a landowner rights question.
Okay.
I own a piece of property that is state game land on two sides of my property and Federal Army Corps of Engineers land on the other two sides. And I've been having some issues with having access rights. I do not have a deeded right-of-way through either property. However, my current access is through the federal land.
Mm-hmm.
I've been trying to do some improvements to the property and have been getting resistance from the Army Corps because of my access rights. Now, I know in the state of Pennsylvania, I heard you cannot own landlocked property. You must be allowed access to your property, even if it's through state or other privately held land.
Basically, yes.
So my questions were pertaining to that. What are my rights as a landowner, and as far as having access and the ability to improve my property?
You have to be truly landlocked. So first of all, I don't know what type of access it came with, but if you have
access, is I actually enter an Army Corps of Engineers complex,
right?
Campground, outdoor reservoir type complex.
And that's the question is do you have effective access? I mean, if you do, then you don't have the right to force it. But if you do own land, and I'll give you an example. Let's say you don't have any other way to get in, or no adequate way. You can go through. Pennsylvania has what's called the private condemnation Road Condemnation Act, which allows you to push a road across somebody else's property. Now, I don't know about federal property because that creates a whole little issue in my head saying, that's the U.S. government's property. Pennsylvania law, as for private condemnation, might not apply there, but the game lands would certainly apply.
Right, and there is a road from the game lands that accesses my property from the opposite side. However, it's not open to vehicle traffic. I mean, it can certainly uphold vehicle traffic, but for the game lands priorities, they have that section of road blocked off to vehicles.
Right.
So I would have to be circumventing their common practice.
Yeah, and what you would do...
I didn't know what the process there is or how, my rights regarding that option.
Well, we would have to do a thorough history of the land. The first thing we'd do is do a title search, go back and study the history of how and when that came to be, that it got landlocked, essentially.
Okay.
Determine what, if any, access and right-of-ways you currently enjoy or might be able to enjoy and whether we can make an argument about their adequacy. And then we'd also look at where's the best place to push a road out to give you full-time or permanent access. And the game lands or the Army, either one may have to live with what you want to do under Pennsylvania law, but you do have to pay them compensation for it. So we'd also look at, what's it really worth? And so to me, pushing across the game lands where it's not going to be developed or never will be developed anyhow is probably going to be your cheapest option because that's not land that they're going to say, well, we were about to build a subdivision on it.
Correct.
So, but Corey, you definitely need to sit down with a lawyer and go in depth on that if that's what you're interested in doing.
Okay.
All right.
Thank you very much.
Thank you. Take care. 540-0580. Tom, you're on WHP 580.
Yeah, just a point of clarification or question on the caller about divorced couples having to pay for college. That may not be totally true because if they want to request financial aid, don't they have to together, even if they're divorced, file the FAFSA form and the college determines what the family contribution is before aid is provided?
Right, but neither parent has an obligation to pay that.
Oh, I see. But they still will determine what the divorced couple's family contribution will be, even if they're not obligated to pay.
And so we get into these positions, though, where that gets to be the fight. If you can show that mom or dad's a deadbeat and completely uninvolved and nobody knows where they are, etc., sometimes you can remove that leg of the family contribution. But what they worry about and what we've seen done is obviously you've got daddy making $150,000 a year and you got mommy making $30,000 a year, and they say, oh, we've been divorced for a couple of years, and so we're going to use mom's salary because that's where kid lives right now, and that's why they've said no, we need to know what's really going on here. Is this person reasonably available to the child or not? The problem is, even if they are, they still don't have a legal obligation to pony.
Yeah, but they do have to file. If they want financial aid, the parents do have to file that FAFSA form together. Is that right?
If you can make them do it, right.
If you can make them do it. What is your understanding of what it takes for a student to be totally emancipated after high school so that parents aren't involved or don't need to be involved in the eyes of the college to qualify for financial aid?
I do not know what the exact answer on that is. In all fairness, I can tell you that I know that the usual fight is, what are we looking at? Where has dad been? Where has mom been? And if you can show that there's been no support paid and no contact for many years, a lot of times they won't hold you to that.
But they probably look back several years, not just one or two.
Oh, yeah. It's not something you can really plan for, or if you're planning for it, you're going to have to really be a schlep for a long time.
Right. Okay, thanks.
All right, man. Got to go to break here. 540-0580. I'll see you folks after the break.
Now back to Weekend Appointment with Carl Rominger on WHP 580. Call toll-free 1-800-724-5801.
Oh, they got that long intro. I don't know why they do this. 540-0580. 540-0580. They shun the 800 number now because they're running out of money here. But what can I tell you? George, you're on WHP 580 with Carl Rominger. George.
Yes, George. This is George. Yeah, I have a question. We have a 32 acres of ground in Sullivan County.
Okay.
It's a hunting camp, and we received an offer from a mineral company.
Okay.
And they want to give us X number of dollars for our land. and they say we're the mineral rights owners, but we have a deed that says in 1913 they were sold to somebody else, and we had a lawyer check it. He said yes, they were sold, but we don't know who owns them now or if they still exist. Or is there a way we can really find out?
Right.
You know, or should we just sign this paper and let them give us the money?
Well, the short answer is that's it's let the buyer beware. I mean, in other words, you wouldn't want to warrant, because what we do when we write a deed is we warrant that we own it. What you would want to give them is a quit claim deed or similar type document that basically says, okay, if you want to pay us for it, we're not sure that we own it, but if we do own it, you can have it. Or at least to the extent that we own it, you now own it. And that, if they're willing to pay, they're willing to pay. And if you have a lawyer who says he thinks that the mineral rights are already not yours, then was that money for nothing?
Yeah. So we just get a lawyer to make up a quick claim deed and stating that, and then send that along with the offer and say, you know, if you guys want to give us the money, fine.
No,
we're not sure we don't know own it or not.
Yeah, but you're going to want to know what they want from you. In other words, when you read that offer, it may say we're only going to pay you if you transfer this type of title or that type of title. I don't know what the offer really means. And they may have sent these offers out by the hundreds. There's a big mineral hunt for gas and other things going on across Pennsylvania right now. Where
right, that's what it is. It's like $2,000 an acre.
Mm-hmm.
And, It's like $60,000. So
right now, the flip side is, of course, it may turn out later on that that's a great deal, and there might not be offers similar to that down the road, or it may turn out that people who hold out get a lot more per acre. That's a business decision.
What if we would send that back signed and they gave us the money, then we found out later we didn't have the mineral rights?
Well, that's a problem, and what I mean by that is you've got to be clear. I don't know what your agreement says, what they've sent you, okay? It may have language in there that says, I certify I own them. It may have language in there that just says, to the extent that I own them. So I don't know what you're saying. You don't want to make a fraud or misrepresentation.
Yeah, they said that, you know, we have done research in the county and found out that you're the mineral rights owners. And our research says we're not. But we don't know whatever happened to those people from 1913.
Right. And when you're the seller, you got two options then. One is you can let them buy any right or interest you have and let them worry about that later. Or you can quiet the title, whereby you file an action, try to locate the would-be owners and say that there's no additional owner anymore, and we want to quiet the title so that we are back to fee simple estate in both the surface and mineral rights. You got a couple different options, but you want to work with your lawyer on that.
That's quite an involved process to try to find people from 1913.
You're right, it is. The flip side is that the law has a few tools for that, and if you do certain diligence, a lot of times it ends up with some newspaper ads. So
okay, well, but would we have any real liability if we sent that back in? They gave us the money.
I don't know what you're signing. Can I get that through to you? I don't know what it says. If it says, under penalty of perjury, I swear up and down I own this mineral right, then you got a problem. If it says, to the extent I might own a mineral right, then it's okay.
We were thinking of signing it and sending an addendum in it with saying that we're not sure we own it, but if you want to look at it and give us the money, but we're not sure. But if you say we are, we'll take the money. And that's
a safe way to go, as long as you're clear to them that you're not warranting and assuring them that you're selling them something that you're not sure you own.
Well, that's what we were thinking. Let them do the research.
But I would make sure you have your lawyer draft the addendum so that the language is clean.
Okay.
All right?
Okay. But that may be the avenue to go, though.
Yeah, George, if somebody wants to give you money for the possibility of something, why not?
Okay.
All right, brother.
Okay, thank you.
All right. Yeah, I mean, come on now. If somebody wants to give me money, I've got swampland in Florida. Maybe I own it, and I'll sign you a deed over to it. And if you're really willing to pay me for it on the promise that I might own it, knowing that I might not own it, well, that's a business decision. And we're talking about crazy money, folks. I mean, this guy says, well, it's $2,000 an acre, and they want to throw money at us. They may well know that's $2,000 an acre, and they might not get anything for it. What they're doing is they're throwing out $2,000 an acre times 100,000 acres. Do the math on that, like $2 billion worth of money to buy up mineral rights, and then they're going to find $10 billion worth of gas down there, and they're going to be $8 billion up. They're going to subtract their costs from it, and somebody's going to make billions. So it's quite conceivable that there's somebody offering them $2,000 an acre for the chance. So that doesn't surprise me one bit. Dan, you're on WHP 580 with Carl Rominger.
Yes, hello. My question was, I have a small trucking company, and a customer of mine asked me to haul load, so I did, and sent them a bill for a price that we both agreed upon. And they came back and said, oh, we need proof of your insurance before we pay you. So I sent them the pages I thought they needed, and they said, no, you don't have the insurance that we want you to have. We're not going to pay you.
But you'd already done the work, right?
I already did the work. It's done. Nothing happened.
Right.
They say they're not going to pay.
Now, to me, the answer there is, I certainly could understand them saying, okay, wait a minute, we're not going to use you in the future because we need you to have this insurance. But you performed.
Yes.
And you performed without incident.
Yes.
They owe you. You can sue them.
Okay.
All right?
Cool. Okay.
Pretty simple to me.
Okay.
I mean, that's one of those things like, well, yeah, I know you did all the work and you did everything we wanted you to, but now we found a technical reason not to pay you. It doesn't work quite like that. Now, if in the original agreement you certified you'd have insurance, maybe you'd be in breach, but again, you still would be entitled to a quantum of compensation for the work you performed. So it doesn't. Their position is totally untenable. You should win handily.
Okay.
All right.
Thank you.
All right, brother. Go get them. Yeah, I mean we're not going to pay. We got a technical No, it doesn't work like that. Larry, you're on WHP 580 with Carl Rominger. My talk line number is 540-0580.
Hi, Carl. Let's see if we have a totally untenable position with this issue. It's about consumer rights and one's on-the-spot actions that one can take regarding posted pricing of merchandise.
Okay.
If we go to a grocery store and a clerk's put the product up in a sale area and it doesn't belong on sale and we buy it presuming it's on sale, we take it to customer service, and usually, at least in this market, they give us the difference back or even give us the product for free.
Right.
However, there's a fast food chain in this, a convenience store chain in this area, on North Progress Street Avenue to be specific, that has a posted price on one item, and it's at 79 cents.
Right.
And repeatedly, the manager of the store tries to charge $1 or more for the item, and we've almost gotten into fistfights with this guy. That's issue one. What is our standing there? The other one is, this past week we went down to an event at the Giant Center at Hershey Park Arena, and driving in, of course, Herco wants to charge outrageous fees to park at the facility.
Right.
And they had posted a price of $7 at the toll booth. We had our $7 ready, grumbling, of course, all about it. But when we got to the window, the guy says, "You owe us $10." And that is posted at $7. He says, "Well, that's for sporting events. This isn't a sporting event. You owe us $10." We begrudgingly paid the $10 and went on in. Now, what's our standing as a consumer in those issues?
Well, the short answer is there are some laws that say that they're supposed to charge the posted price. The flip side is you have to be careful. You don't have the right to breach the peace, for instance. So, and go back to your fast food example.
Okay.
And the other thing is, if you keep going in there repeatedly, at what point are you going to have somebody going to say to you, "Hey, well, stop going back. If these guys keep trying to rip you off, you can't just keep walking in there and saying, well, you say 79 cents, you charge me $1, and I'm all distressed about it." You kind of knew that was going to happen when you walked in there because it's happened 3 other times.
But wait, in that particular case, it's not always the case. Once in a while, the merchant would charge us the correct price, 79 plus sales tax. But when it comes to like the Department of Revenue, can we file a claim against them and say this guy's charging a de facto 12% sales tax?
The short answer is no. I mean, the answer is you're going to have to make a claim for any overcharge. But if they actually straighten out the price with you, then there's no harm, no foul. Mm-hmm. And there's no emotional distress for this. As for the Herco thing, you might have a case there to get your $3 back. But usually you're going to be able to accomplish that with a letter of explanation to them saying, here's what happened. We saw the post at $7. We agreed to pay $7 to park on your parking lot. We got all the way up to the toll booth, and it's like you got a gun to our head at that point because what are we going to do, back all the way up? So we paid the extra $3, but it's improperly posted, so give us back our $3. And if they don't, maybe you can take them to the district justice.
Okay, that's a good suggestion. We'll pursue it and see what happens.
All right, Larry, have fun.
Thanks, Carl.
540-0580, 540-0580. I'll see you after the break.
Let's return to Weekend Appointment with Carl Rominger on WHP 580.
Hey, welcome back. I want to let everybody know we now have podcasts of the show available. So you can either go to the WHP 580 website, but why would you do that when you go right to weekendappointment.com? Go to weekendappointment.com. It's now going to be the second one down, podcasts of past shows. We put up 3 demo shows, so 3 older ones. And going forward, we're going to put up each show as they become available. And you can also get them, like I say, at WHP580.com under podcasts, as well as all the other podcasts there. So if you missed something during the show and you want to hear it over again, you can do that. You can go back and listen again. If you want to listen to an old show and see if there's some advice in there you might have been able to use, you can do that. I just want to let everybody know the podcasts are up and will be kept current going forward. Sandra on WHP 580 with Carl Rominger. Sandra.
Hello?
Yes.
Yes, this is Sandra. I was rear-ended by a company in Lancaster, and at the time, it was just a minor accident. We pulled off to the side of the road, and we had parked in a shaded area, and I didn't realize it at the time. It didn't look like there was much damage on my car, so I just took down his name, the name of the company, and I didn't get the insurance information.
Right.
And then later I drove to a parking lot that was in full sun, and then I saw these scratches. And so I called the company, and now they're not cooperating. You know, they don't understand how did my truck make those damages. And they came up a second time. The actual driver came up. The owner had said he was going to come up, but the driver came up and took pictures, which pictures are not going to show anything.
Right.
So that's been 2 weeks. And because it's under my insurance deductible, my insurance is out of the picture. And so, my insurance says my next step would be maybe take them to small claims.
Right, and that's basically your remedy is to take them to small claims. They either have to pay it themselves or put it through to their insurance company. Obviously, damage that doesn't show up on picture is going to be problematic because you're going to have to present it somehow to the court. What you probably need to do is one of two things. Either document it somehow or go get it repaired so you have an actual repair bill and then use that repair bill as your proof of damages. But you can always run into a situation where the fact finder might not determine that the damages were caused, even if they were, in that particular accident. So courts can still get it wrong.
Uh-huh.
So, yeah.
Well, I do have an estimate, so that's not enough to go into small claims court.
It is enough to go into small claims court. You can testify that, yes, I got an estimate, and the estimate amount is blank. If the other side's clever, they may keep you from actually admitting the actual estimate itself. But a lot of small claims court procedures, the judge is going to say, I'll allow it for what it's worth, and then determine whether or not it seems fair and reasonable. I had one judge one time actually go out in the parking lot and take a look at the car himself and tell the side that was suing my guy, your car's not very good looking to start with. Maybe it's worth a few $100.
Uh-huh. And would sending a letter from a lawyer, is that helpful?
Yeah, that helps.
Should I do that first before I go to small claims?
It depends. You could probably take it to small claims yourself. It's 6 of one, half dozen of another there without knowing more about the accident itself or the damage. But if you asked me, like, what would I'd always start with the lawyer.
Okay.
And then the lawyer could say to you, well, here's what I would charge for small claims, but if you don't want to use me, here's the form you need to send in, and here's what you need to do.
Okay.
All right, Sandra?
Okay, thank you.
Good luck.
Bye.
540-0580. I do want to take I did get an email. Dear Carl, I was hurt in an auto accident. There is about $50,000 in coverage, and I think I can collect between $25,000 and $40,000 of it. This person must have been injured, obviously. I saw a lawyer, but they want 1/3 for what would probably be a few letters. Is this a normal fee? It's a contingency fee, and if you've been injured in an auto accident, lawyers usually charge a percentage. A 1/3 contingency fee, if the case can be resolved literally on a few letters, is probably excessive. 25%. So just by way of example, when I sign up an auto accident case, we have one fee, usually 25%, and another fee 1/3, depending on how far into the case we have to get, so that if it can be resolved quickly and easily, the client gets a discount rather than paying 1/3, they pay about 1/4. The reason for that, why some people go, oh, it should be 10%. Well, the answer is we box everything up. We get everything together, and we know what things are worth. We know how to put them together. We know how to write the demand. We know which insurance companies are reasonable and which ones are unreasonable, which would be most of them. And we know how to present it to maximize the value. So we find even when we take a quarter that we get people more money than they would have anyhow. So a third might be reasonable because you're saying it might be a few letters or written back and forth. It might be more than that, and the lawyer may already realize that. But usually you should look for a fee agreement like the ones I use where there's multiple fees that escalate depending upon how far the case goes. That way the lawyer gets adequately compensated if they have to fight it out. At the same time, you get a discount if the lawyer is able to package it up and solve it quickly. And I think that's fair to both sides. So that's the answer to the email there. Also want to remind you, go to weekendappointment.com throughout the week to post your legal questions so I can answer them. I've been answering quite a few this week. We're getting a lot on divorce and child support and some other issues as well. Lee, you're on WHP 580 with Carl Rominger. My talk line number is 540-0580.
Hello?
Yeah, Lee.
Yeah, hi.
Hey.
How you doing, Carl?
Good.
Good. I have a question.
Yeah.
How long does I have a bill from, it's a medical bill that will be 5 years old tomorrow. A collection agency just started collection or trying to in May. How old does a bill have to be before, it's like, is there a statute of limitations? Yeah,
there is, although it's a little complicated because it's the statute of limitations from the time you breached a contract. So usually we would say the failure to pay 4 years. Mm-hmm. But if you paid any amount on it during that 4 years, then that resets from the time you make the last payment.
Well, the problem is I've never heard from the hospital, never.
Right.
And all of a sudden, in May, I get a bill from a collection agency.
Somebody may have bought up an old tape of when I say tape, an old computer file of names and amounts, and they just start collecting them. And the funny thing is, there's two things they can do. One is if they can get you just to pay, sometimes people are like, oh, they were so reasonable. They called me and said, you can just send $25 a month. We'll work with you on this. Mm-hmm. But once you send that first $25, if you owed me money from 10 years ago and I'd never pursued it, and I can get you to just re-acknowledge the debt by paying any amount on it, then we reset our statute of limitations.
Okay, I haven't paid anything.
Right. So theoretically, you have a statute of limitations defense, and when they sue you, you can use that to block the lawsuit.
Okay.
All right?
Wonderful.
Good luck.
Thank you.
Yeah, that's always a... Don't ever pay on a debt you don't owe either. I go crazy about this. People go, that guy wanted $600 from me, and he told me I owed him $600, and I didn't owe him $600, but I sent him $50 just to get rid of him. Well, you've acknowledged the debt by paying down on it. Don't ever pay down on a debt you don't owe. Don't ever let anybody bully you into that. Come see a lawyer first. Sue, you're on WHP 580. Sue.
Oh, hi, Carl. I have a question.
Yes.
I live in a townhouse community with a homeowners association, which to date has been run very poorly.
Okay.
We have the bylaws and the rules, and pretty much none of which have been followed or enforced so far.
Okay.
The bylaws haven't been followed by the board, and yet every year they raise the monthly fee. We're not really getting the services we're supposedly paying for, and I know that's a matter of opinion, but my question is there any recourse or any way to, stop paying the monthly fee or to opt out of it or anything like that?
No, you're stuck there. Your two options are this. One is a political option, which is to go rally the neighbors and elect some new board members who are going to do things differently. Sometimes there's a takeover, or get somebody who represents a faction of dissatisfied homeowners on the HOA board itself. The other option is you have standing legally to say that the HOA is not following its own rules or not doing things that it's supposed to do, and then litigate that way. As a member of it, you can say that.
What is that standing?
You have standing to litigate that. I mean, in other words, as a member of, I can't do anything to your HOA, right? Because doesn't matter what they do or don't do to me. But as a person who lives in it and is a member of it, you can complain that they aren't following their own rules and following the bylaws.
And complain to who? Complain to them?
To the court. Get a court order to require them to follow through. Now, that costs time and money. Now, here's the next deal. once you start that kind of litigation, you also might be shooting yourself in the foot because let's say you decided you needed to sell the house. Now suddenly you've got an HOA that's in litigation. That may make it less attractive to prospective buyers. Usually what I tell people to do is get out of the HOA by moving if it's completely as dysfunctional as you think it is.
Yeah, that's the obvious solution, and that's kind of what I figured, but I thought I'd ask just in case.
Yeah.
Okay, thank you
All right.
very much.
Good luck, Sue. Yeah, HOAs, that's a big question a lot of the time, folks. 540-0580, 540-0580. Don't forget to go to weekendappointment.com. This is Carl Rominger. I'll see you after the break.
Let's return to Weekend Appointment with Carl Rominger on WHP 580.
Hey, welcome back, 540-0580. Make sure you go to weekendappointment.com, become a registered user. I want to let people know here at Thanksgiving time, we're going to be giving away some substantial prizes but in order to get them, A, you're going to have to be a listener to the show, and B, you're going to have to be a registered user at weekendappointment.com. And it's painless. You just sign up, give us about 5 minutes of your time or less. You become a member. It gives you access to the members only area, gets you the free will, gets you access to some photos and things like that, lets you do a lot of different stuff. Go to weekendappointment.com, become a registered user. We're going to have a big giveaway here for Thanksgiving. We're going to make it worth your while. It's not going to just be turkeys. There's going to be some really good gift certificates and some other things, and I'll be telling you more about that after Halloween here because I don't believe in getting one holiday in front of the other, but I want to give you a heads up. So if you're not a registered user at weekendappointment.com, do that today. Do that tomorrow, but better do it today because you'll never get around to it or remember, and I'll have to remind you again next week. So make sure you become a registered user so you're going to be able to qualify for our Thanksgiving giveaways here. And who's next on the lines? Let's see. Dale, you're on WHP 580 with Carl Rominger.
Hi, Carl. I have two questions for you.
Yeah.
One is I'm behind on a payment. It's my fault I'm behind. But less than a month. The company has been calling me 4 to 6 times a day, and when I ask why they're calling so much, they say it's their automatic dialer, and they're allowed to do that.
Well, the short answer is, are you talking with them that often, or are they just dialing and waiting for you to pick up?
Well, I talked with them once or twice. The other 3 times, it's an automated machine.
Gotcha. Short answer is, at some level, I think it becomes harassing, and I'm not sure they're allowed to do that. What they're going to say is, well, we're trying to get a hold of them, and when we actually talk to them, we stop dialing them for the day. I'm sure that's what they're going to tell us. But
Actually, they don't.
To keep track of that. You might have a claim there. And stop doing business with those people if you can.
Well, unfortunately, it's my car payment. I don't got a choice.
Gotcha.
But the other issue is, and I thought this was illegal. I don't know if it's true or not, because I don't like doing it. When they do talk to me and I tell them, look, I'm behind, I'm trying to get things arranged, well, why don't you give us a post-dated check?
Yeah, technically that's illegal. In other words, you're not supposed to issue a post-dated check because when you issue that instrument, it's supposed to be good at the time you issue it.
Yeah, and when I told them that, I thought that was illegal. They kept telling me, no, it's not. We're allowed to accept them.
Well, they're allowed to accept them. That's true. And I mean, we all know that post-dated checks are routinely change hands. The problem is theoretically, you uttered the check or you issued the check, and then if I take it to the bank and utter it, meaning ask them to honor it, they should tell me, well, it's not good on the date, but theoretically, there was supposed to be funds in there at the time you issued it. So yeah, I recommend against doing that.
That's why I hate doing it. In fact, I refuse to do it.
Yeah, I recommend against doing that. All right, Dale?
Thanks.
All right, man. See, Sherry, you have a custody question on WHP 580 with Carl Rominger. My talk line's 540-0580. What's going on, Sherry?
Hi. I had a question about, actually, it wasn't custody. It's paternity. Is the county or the state able to force someone to take a paternity test?
Absolutely.
They can. Okay. That was pretty much my question. My husband's ex-girlfriend, after 8 years, is now claiming that her youngest daughter is
his. Well, wait.
But yet, her boyfriend at the time was in the delivery room and signed the birth certificate.
And let's be careful about this because I answered the question yes, but I should caveat it as you can block the genetic test in many circumstances.
Okay.
And so I think of a case that I had where it went up and down through the courts over 4 years, and we ultimately blocked the genetic testing of a child on the theory that the mother had held somebody else out as the father, and since that child basically knew somebody else as the father, there was more harm in getting a genetic test in that case than not, and that even if my guy was the real father, it didn't matter legally anymore. And that's called paternity by estoppel. So you should consult with a lawyer and not necessarily simply allow her to bamboozle him in. And here's the thing. Remember, I always tell people, the police are not your friends, the government's not your friends, they have a job to do.
Right.
Well, when you go walk into domestic relations, you say, do I have to take this test? A lot of times they're just going to say, yeah. They're not going to worry about all the nuance that a private lawyer might be able to bring to the table and say, hey, wait, he doesn't really have to take this, and here's why. And then a judge determines that. But they're not going to tell you that.
Okay.
And they're not going to help you.
All right.
They're not your friends.
Thank you so much. Well, that's kind of what we thought, that 8 years, this little girl has known someone else as her father, and to do this to her I just don't see the point.
Well, I'll tell you when this comes up. This comes up under one of two scenarios.
Well, they're having a problem with custody.
Right, and then they're having a problem with custody, right. And then the mom wants to go ahead and say, well, you know what, I'm going to win custody anyhow because it's not even really your kid. I see it that way.
That's exactly what was said.
And I see it the other way all the time where turns out that potential other daddy makes a lot more money, so maybe
that
if I...
also.
So just look me up at weekendappointment.com if you want me to help you out with this.
Thank you so much. You've
All
been
right.
very helpful. Appreciate it.
All right, take care.
You too. Bye-bye.
Isn't it amazing? You see these things again and again, you start to know what triggers these events. 540-0580. Don't forget to sign up at weekendappointment.com. You're going to have to be a registered user if you want to win that stuff here in November. Daryl, you're on WHP 580 with Carl Rominger.
Thank you, Carl. I have trees on the property line, and I cut some down, and it upset my neighbor.
Okay.
Fortunately, they were on my line.
Right.
Now, these on the line, if I were to cut them down and half of them are on his side, what's going to happen?
Well, you can't cut down the trees that are on his property. You can remove the portions of those trees that are on your property.
Huh. Yeah, but you can't cut down half of a trunk of a tree or anything.
Right, that's correct. So you run into a problem there.
When if he would sue me, these are 25-year-old white pines that are 50, 60 feet tall. What would I be sued for half of the amount of the tree, or what?
Yeah, theoretically, could sue you for damages to the tree. Maybe. You know what? I'm thinking of the tree case, and I posted one on weekendappointment.com a while back. There's always a little nuance, but basically, if those trees are on your property, you're allowed to remove the portion that's yours. Obviously, that's going to kill the whole tree. I'm not certain that that's even actionable.
Oh.
But I would want to spend a little time with you actually getting some pictures of this, looking it up, and taking a little walk through the case law. You'd be amazed how many property line tree cases there are, and they always turn just a little bit differently. My instinct is you can remove them, but you can't trespass on his land, which is also another problem.
Oh.
That's my instinct, that you can remove them without opening yourself up to any action if there are enough of the trees on your property.
Mm-hmm.
The flip side is you can't enter his property, so the two of you might have to reach a detente, or you might need to go to court first and get permission from a court to do a limited trespass for purposes of removing the tree.
Well, I could take them down from my side. That wouldn't be a problem.
Gotcha.
So.
All right, my friend, I don't have a great answer for you without really doing a little... this is the kind of thing where probably you'd want to spend an hour with the lawyer, and we'd try to figure it out and give you a better answer.
Okay.
And then usually what I would do if I thought we had a good position is write your neighbor a letter and say, here's what we intend to do. Give us a written reason why we can't, and we'll take it to court. Otherwise, we're assuming you're okay with all this.
Okay. All right. Thank you very much.
All right, my friend.
All right.
Let's see. John, you're on WHP 580 with attorney Carl Rominger.
Yes, this is John.
Yeah.
How you doing, Carl?
Good, man. How are you?
All right. I got a question about an employer that says you cannot use cell phones on the job anytime on his while you're on the payroll. Now, from the notice we got, that's what he's saying, but yet they still call us from different places to tell us where to go or what plant to go to or whatever. They do that on their own. Now, is that we don't get no breaks, we don't get no lunch, we don't get anything. Now, is that legal for them to do that and say that we can't use they say that they will have our family notified, or tell our family to notify them of if there's any medical problems or anything like that.
The short answer is your employer can basically make up any crazy rule they want and enforce it. I'm not sure that they can fire you for an occasional use of the phone on an emergency basis, but the flip side is they do own your time while you're working for them. So I don't know, John. I don't know. It doesn't sound good. It sounds like they could do that, but it sounds like you should be able to keep the phone for emergency. That's the music. I got to go, my friend.
Okay, I have...
Gotta go. Sorry about that. Go to weekendappointment.com. Make sure you're registered there. Folks, we're going to do a big giveaway here in November, so if you're a registered user, you're going to qualify. It's weekendappointment.com. I'll see you guys next week. It'll be Halloween, so maybe we'll do, I'll dress up.